Good afternoon, everyone. My name is Renzo Marchini, and I'm a partner in the Data and Privacy team in London. Welcome to another of our privacy webinar series. We do normally try to schedule these on a monthly basis, but as with the emergency one we did in May in the wake of the Irish decision against Meta's transfers, occasionally events overtake us. So we have adequacy for the data privacy framework. And over the next hour or so, we're going to try to shed some light in it with a focus on practical steps to take. Delighted to be joined, in fact, with the same team that presented with me the Meta decision in May. My partner, Sarah Tedstone, no longer new. She's been with us a couple of months. And Camille Ebden, who was a senior associate back in May, but is now a director in our team. Congratulations, Camille. We are going to cover, if I can get the slides to move forward, a few different things. I will summarize briefly how we got here. I think it's important to do so because the Schrems decision, which led up to it, will shed some light on some of the consequences of the adequacy decision and executive order underpinning it. Camille is going to talk us through the actual framework principles, how they differ from the Privacy Shield that preceded them. Sarah will talk us through how to certify and practical steps and timings that you need to bear in mind. I'll talk about some wider points around what the developments actually mean for other transfers to US companies not in the framework, or indeed wider field than that. Sarah will then sum up at the end and give some views on other considerations. We'll try to finish within the hour, as we always do. Please ask questions to us using the question function on your screen. We've allowed time for that. We'll try to take pertinent ones during the discussion itself, if convenient, and if we know that they're not going to be answered later anyway. And to those that we don't actually have time to cover, we will try to answer in writing in due course. Our framework, our transfer webinars do tend to provoke quite a lot of questions, and it might take us a little while to go through them. Don't feel like you need to scribble everything down. You'll be sent slides. You'll be sent a link to the recording, which will be posted on our YouTube channel. Do subscribe to our YouTube channel. Do subscribe to our blog. And keep an eye out also for other webinars in the coming months. So just then to set the scene, and for people that are absolutely new to international transfers, GDPR, both the EU and the UK version, provide the following structure to when you can send data out to make sure that the data is still protected. You can send data out if there is an adequacy decision in relation to the destination, and that of course is what's happened to US companies in the framework. If you haven't got an adequacy decision, then you can put in place appropriate safeguards to protect the data. The most common one being standard contractual clauses, but binding corporate rules also exist, and one or two others, even more esoteric ones. And if you can't protect the data either through adequacy or appropriate safeguards, then you might be able to rely on derogations such as consent. I want to talk a bit then about how we actually got here. And you have to wind back 10 years to Mr. Schrems first complaining to the Irish DPC because Facebook Ireland was sending data to Facebook in the US. It went through a bunch of procedural wrangles and ended up in the Court of Justice of the European Union, and Safe Harbor, predecessor to Privacy Shield, was declared invalid in 2015. After that, the framework was the Irish DPC started commencing proceedings against that, and then the Privacy Shield was in fact adopted. In July 2020, the CJEU in turn declared Privacy Shield invalid for various reasons. Now, the main criticism of the CJEU in Schrems II was that the protection given to data by Privacy Shield was not essentially equivalent as required by GDPR. There was still, under the problematic laws of the US, which was FISA 702, the possibility of mass surveillance which went beyond what was strictly necessary in a democratic society. There was no effective remedy under the legislation in the US for EU citizens before the courts against the US authorities. There was supposed to be something called the ombudsperson, well, there was something called the ombudsperson in Privacy Shield, but that didn't count as an independent court as required by EU treaty law. So going a little bit further forward, in 2021, there was new SCCs, there were new SCCs, and there was guidance from the EDPB, the European regulators, on how actually to transfer data using standard contractual clauses. And as everyone knows, because people have been involved in various repapering and transfer risk assessments, the EDPB said that you can actually use, the CJEU, sorry, and the guidance embellished on it, said you can use SCCs as long as the SCCs were appropriate, supplemented by measures which will fill the gaps in US law. In March 2022, there was a cross-Atlantic agreement in principle to the framework at the governmental level. And in October 22, President Biden issued an executive order to fill some of the gaps that were highlighted by the CJEU, which I just mentioned. And in December of that last year, we had the draft adequacy decision, which was finally adopted last week. So the executive order was the important missing piece for US law here. And what it did was that it actually included some safeguards for US intelligence activities, protecting data regardless of the nationality of the individuals. Signals intelligence activities, it says, must be necessary and proportionate, so fixing that hole, and for itemized national security objectives which are set out in the order. There must be oversight for the data in terms of when can there must be an assessment, when can bulk collection actually can take place, and that must be restricted to certain, like I said, itemized objectives. And importantly, there was a creation of a redress mechanism. Individuals from qualifying states, not all foreign non-US countries are qualifying states, only those where there's basically reciprocity. So EU countries are currently qualifying states. Well, individuals from those countries can seek redress. They can complain to a civil liberties protection officer and ultimately appeal to a data protection review court. We haven't got time to talk about exactly what the executive order means constitutionally in the US and whether or not they actually do fill the gaps that the CJEU identified in Schrems II. NOYB, we know, has criticized this and different views can be taken. But of course, the executive order is in place, and that did pass muster in the eyes of the European institutions in adopting the framework adequacy decision. In May, as mentioned, Facebook was actually banned because of Schrems II from sending data outside the EU, with a nice grace period of not having to actually stop for a few months. And that, of course, allowed what in fact did happen last week, a finalization of the adequacy decision at the EU. The framework will eventually protect data for the UK, and Sarah's going to talk about how to certify. There is a UK extension of the framework envisaged. There is a Swiss extension of the framework envisaged, but the UK needs itself to issue its own adequacy decision, and Switzerland needs to do likewise, and they haven't yet done so. As I mentioned, Mr. Schrems is complaining, and I'm not going to read these quotes, you can read them for yourself, and has said that there will be a challenge in relation to this. He says that it might reach the courts by end of this year or end of next year. It'd be a nice little poetic symmetry. If there was going to be a Schrems III, then that should be in 2025, every 5 years. And hopefully this time the framework will survive where the Privacy Shield and Safe Harbor did not. And I will hand over now to Camille.
Thanks very much, Renzo. So a quick mention before we dive into the principles that not all US entities are able to become framework certified. So at the moment, it's only US organizations that are subject to the investigatory and enforcement powers of the FTC, the Federal Trade Commission, or the US Department of Transportation. The framework has carved out that this might be extended in the future. US organizations who at the moment wouldn't be able to get framework certified includes banks and certain other depository institutions, telecom organizations, most non-profit organizations, and most insurance companies. So why do the principles actually matter for organizations who can and do wish to become framework certified? Well, they matter because in order to become certified, organizations have to publicly declare their commitment to adhere to the principles, and they have to comply fully with them. So what exactly are they? As per the Privacy Shield, we've got 7 main principles supported by 16 supplemental principles. Now, the headings of these principles remain exactly the same as per the Privacy Shield, and there are only a few substantive changes to the content of the principles. But before I actually dive into what's actually changed, I'm just going to run through an overview of the 7 main principles for those who aren't familiar with them. So you can see that the first one is notice. So US organizations who become framework certified have to provide certain information to individuals, which is similar to some of the information that has to be provided under the GDPR, including the types of personal data that's collected, the purposes that they're used for, certain information about recipients, and certain information about rights. Differences include that you have to, of course, set out that you participate in the framework. You don't need to provide legal basis information, and you need to provide details of the independent dispute resolution body that you designate to address complaints and provide recourse under the framework. So moving on to the choice principle, this sets out that individuals must be given the opportunity to opt out from having their personal information, 1, disclosed to a third party other than a processor, or 2, used for a materially different purpose from the original purpose at collection. Thirdly, we've got the accountability for onward transfer principle, and this sets out the requirements that must be met by the certified organization in order to onward transfer personal data to a third-party controller or processor. For example, the third-party recipient must only be allowed to use the data for certain limited purposes, and they must be obliged to provide the same level of protection as there is under the principles. And Renzo is going to discuss this further on. Fourthly, we have the security principle, and this sets out that organizations must take reasonable and appropriate measures to protect personal data, taking into account the risks involved in the processing and the nature of the personal data. So fairly similar to GDPR. And then we have the data integrity and purpose limitation principle. This in short requires that certified organizations must ensure that personal information is limited to the information that is relevant for the purposes of processing. So this is akin to the minimization principle under GDPR. Then we have access, the 6th principle. This sets out that individuals must have access to their personal information that an organization holds, a certified organization holds, and be able to correct, amend, or delete that information in certain circumstances. 7th is the recourse enforcement and liability principle. And this details the robust mechanisms that must be in place for assuring compliance with the principles, the recourse for individuals who are affected by non-compliance, and the consequences for framework certified organizations when the principles are not followed. Certified organizations are also obliged to arbitrate claims and follow the terms set out in Annex 1. So that's a quick summary of what the main principles are about. You can also see that there are 16 supplemental principles on the right-hand side of the slide there. But we're going to dive in now to talking about what's changed. So next slide, please, Renzo. Thanks very much. So what has actually changed under the framework principles compared to the Privacy Shield? Well, mostly there are just some small, non-significant changes, updates to definitions, switching references from the Privacy Shield to the framework, the addition of some new footnotes with some examples, and the addition of references to the Department of Transportation, who, as mentioned, along with the FTC, will enforce the framework. There are a few more substantial changes, particularly in the context of the supplemental principles, and we've got a few examples here. So Special Principle 5, the role of data protection authorities. There are some changes to the annual fee that has to be paid where an organisation wishes their independent dispute resolution body to be a panel of EU data protection authorities. Previously, under the Privacy Shield, the fee was capped at $500 US. Now the amount of the fee is to be determined by the Department of Transportation after consultation with the Commission. Then in Special Principle 6, which deals with self-certification, we find actually it has most of the changes that exist, including clarifying when exactly an organisation will be added to the framework list and when they will be removed. It also sets out what details need to be provided to self-certify or recertify, and there are some changes there, including a requirement to now detail the names of the certifying organization's US subsidiaries who will also be adhering to the principles, and the organization wishes the framework to also cover them. Then we have Special Principle 7 on verification, and we find there's some rewording of the obligations regarding privacy policies. So for example, under the self-certification option, rather than requiring the privacy policy to be prominently displayed, it now has to be readily available. So perhaps a slightly softened obligation there. Then under Special Principle 11, dispute resolution and enforcement, there is a clarification that the dispute resolution body that an organisation designates has to be independent. So a few examples there, and I'm going to hand back to Renzo, or Sarah actually.
Sarah.
Thank you, Camille. And I would just like to reassure anyone who is an organisation that isn't able to certify under the framework, a financial institution or some of the lists that Camille mentioned, or if you're a business that's wanting to trade and share personal data with one of those organisations in the US, Renzo is going to tell you what you should do in those circumstances. So we're covering all bases. So if you're in that situation, don't panic. We'll tell you what you can do to carry on with business as usual effectively. So anyway, we have Renzo's told you how we got here. Camille's told you what the principles talk about, and they're fairly familiar. I think you'll agree. I'm going to talk now about how you can certify. Surprisingly, there's a lot, or maybe not surprisingly, but there's a lot involved here. There's a lot of different dates. And I think one of the takeaways that you should perhaps recognise here is that this isn't a quick fix. You can't decide one day that you are going to certify and think that the next day you'll be able to do this. There are some decisions to make. There's quite a lot of work to be done before you can do that. But I'm going to deal with this in the context of different organisations. So if you're active in the Privacy Shield, or perhaps you've let it lapse, if you're thinking about not continuing with the framework from the Privacy Shield, you want to withdraw, or if you're new to this, that's probably the most logical way to do it. And then I'll talk at the end about what certification generally means, whatever the type of organisation or type of application you're making. So I'll talk generally about what's involved, and there is quite a lot involved. So firstly then, let's talk about an existing active Privacy Shield participant renewing to the framework, and he will talk about the Swiss version and the UK bridge that Renzo mentioned too. So deadlines for this. The good news here is that you can have immediate reliance on the framework for the EU and Swiss versions. In fact, your login credentials will even remain live, I'm told. Haven't tested that, but that's supposed to be the case. But a critical point here is that your renewal date does not change, and that's going to be important. I'll mention why now. So there are some slight differences in the dates here by a week or so, and the difference for these dates is just the difference between the date when the framework became effective and the date when the website became effective for some reason. So for the EU, you have a critical date here of the 11th of October, or your renewal date if earlier, effectively. And that date's critical for you because you have to make a public commitment effectively that you're moving over to the framework. And that public commitment effectively means making necessary changes to website, documentation, policies, contracts, etc. Fairly significant. It's not going to be as simple as just changing references to the Privacy Shield to changes to the framework. Effectively, wherever you're talking about how you safeguard transfers or how you deal with transfers, you're going to have to change the wording and change the indication. So you can imagine that extends beyond just a privacy notice or policy. That might go into your contracts, flow downs, and you might have to deal with it within rights, anything that deals with rights processes, complaints processes, that kind of thing. So the date for that is 11th of October if your renewal date is later, but if your renewal date is earlier than the 11th of October, then effectively you need to take that earlier date as making that public commitment, but also your date for certifying to the framework. Swiss version's just got a slightly different date, so it's 17th of October, but again, very similar public commitment and certifying either on that date or by the renewal date. The UK bridge requires a separate certification and it's not standalone. There are slightly different dates for this. As Renzo mentioned, this isn't finalised. The Swiss version isn't completely finalised either, so you can't rely upon this for transfers of personal data. Some of the dates are a little uncertain for the UK bridge, but it appears that you, in essence, practically, you can include the UK bridge within your EU-US certification, or you can opt by January of next year to do that separately outside of your annual certification. Oh, I don't know if it's the same for everyone, but I've lost the slide. There we are. Yes, it's back in. So immediate actions. Sorry, back to the immediate actions, yes, for a Privacy Shield participant, an active Privacy Shield participant. As Camille made clear, there's lots of principles that you're self-certifying to. So you will have to assess your compliance with those principles, identify gaps, and sort out your remedial actions. But this will be checked. This isn't just making a statement to tick the box. This will be looked at. You will have to get independent verification of this compliance, and that will be checked. As I've mentioned, updating lots of documents, and finally certifying and paying fees. I'll refer to fees on your renewal date. Enforcement should be seamless. The Department of Commerce says it's under the Privacy Shield until you commit to the framework, and then under the framework. And we've already mentioned, keep mentioning, that the Swiss and UK version isn't the whole package at the moment. You can't rely on this for transfers, but you can certify to the frameworks if you want to. Right, let's deal with the next one then. Thank you. So if you're an existing active Privacy Shield participant, but you don't think you want to continue with the framework, you can withdraw from this, but it's not a question of just doing nothing and letting it lapse. There is a formal withdrawal process, and you need to have done that effectively before your renewal date or by the 11th of October, because by either of those dates, as you could see from the last slide, there's an awful lot of work to be done. So effectively, that's what must be done. The withdrawal process is an interactive process with the administrators of the framework. There is a questionnaire. There will need to be changes made so that your public statement is making it clear you're not part of the framework or the Privacy Shield any longer. But also you'll have to make arrangements for ongoing treatment of any personal data involved that you're still keeping. Now, ironically, the choices for this are that you are adopting the principles for that data that you're keeping, you're using another adequate method or safeguard such as SCCs, which Renzo will be talking about in more detail later, or effectively you're going to delete or return the data. So enforcement here, withdrawing from the framework, but you've got ongoing commitments and potentially enforcement for any personal data that you're keeping. Okay, let's look at the next one.
Before that, Sarah, we have a question which you might want to take. What's your advice, our advice, for in-house counsel in the EU in terms of existing contracts of US suppliers which currently refer to the SCCs? You mentioned, I think, the last slide that changes ought to be made to contracts now. Do we really envisage a wholesale repapering exercise, or might you just take a view for the time being?
Well, interestingly, one of the directors at the framework himself acknowledged that you might want to be continuing to have SCCs anyway as a sort of belt and braces. So I think being practical, SCCs, and Renzo will talk about, you know, how you deal with SCCs. SCCs are a safeguard that covers you ongoing, and the framework itself anticipates that you might be using those in addition to the framework in any event. So I don't think we are saying that we're talking about a huge repapering exercise at this point.
Thank you.
And again, I mentioned there's a commitment for withdrawal. So yes, the next one then. This is a bit of a strange one, but we think it's really worth mentioning. I've put existing in quotes, you'll see why. This is effectively a Privacy Shield, a previous Privacy Shield participant that's let their certification lapse. So inactive, whether you could really call them an existing Privacy Shield participant is moot. But so we've let it lapse. What about this position for us? Well, if you read the website and the background information for this and the FAQs, it seems that you're probably going to be contacted by the administrators of the framework, and they'll ask you what you want to do. Do you want to withdraw, or do you want to recertify? If it won't be completely straightforward, whichever way you do this, you will have to do some work. If you're going to recertify, it won't be a question of just following what I'm saying about certification. You're going to have to address that gap while you've been lapsed. You will have to clarify, verify that you've carried on with the principles effectively in the gap for any personal data involved, and clarify what you're going to do with any outstanding issues about the delayed recertification. Or you can withdraw, and as per the previous slide, you go into the withdrawal process, which means interaction with the framework administrators and sorting this out. So immediate actions, there are decisions to make. Depending on your decisions, revert to previous slides about which method you take, certification or withdrawal, and enforcement will depend on the choices, but there's likely to be ongoing commitment either way. Next one then, Renzo. So this one then is organisations that have had no involvement with the Privacy Shield before, no certification lapsed or otherwise, and they're now interested in the framework and the Swiss extension and the UK bridge potentially. So it's ready when you are. The website's been live since Monday. You can self-certify. There'll be an annual recertification. There's separate certification for the UK bridge. The website talks about you going into your self-certification application, and there's options to add in the Swiss version and the UK bridge. You can have the Swiss as a standalone on its own, but the UK bridge is as well as the EU version. Immediate actions here. Again, before you self-certify, you've got to have your compliance up and running. So you've got to assess that compliance. What do you need to do to be able to say you're compliant with the principles? What are the gaps? What are the remedial actions? How are you going to verify? What's the independent verification that you've done this and it's working? You've updated all your information before you ask, because they will check and you will have to upload some of it, and you'll have to certify and pay the fee. As soon as you do, you're subject to enforcement by the FTC or the DOT, as Camille mentioned. And as again, though, at the moment, you still need to have another safeguard for transfers for Swiss and UK personal data. Okay, thank you, Renzo. On to the next one. So we've talked about all the different kinds of organisations, some different deadlines involved, but generally, what do you have to do if you are going to certify? So I'm going to talk about now, just briefly, in a way that applies to everybody that's applying to certify, what you'll need to do. Okay, so as I've mentioned, you'll need to have a compliance plan. You'll need to create one. It'll have to deal with the requirements of the principles, the requirements of the self-certification application. So everything else that I'm going to mention from now on, you'll have to deal with within your compliance plan. You're going to have an independent verification process that says, and that must be put in place, that it's checked that your plan is compliant with the framework principles. And by all means, contact us. We're very happy to help with that. As we've mentioned, this is going to involve updating documentation. I mentioned here privacy policies and privacy notices, but we've talked about the potential ongoing that this could deal with any documents that talk about rights processes or complaints processes which will be affected by this. Potentially you will need to consider this with your contracting parties and flow down relationship with supply chain, etc. You will need to select your independent recourse mechanism according to the framework guidance and application process. This independent recourse mechanism has various elements to it, and you can come to us and ask for information about this if you'd like to have more detail about this. But I will deal with this in more detail when I get to the next slide with the arbitration process. Thank you, Renzo. Okay, so we also have to make a required contribution to the binding arbitration mechanism. So we have two elements here, the independent recourse mechanism and the binding arbitration mechanism. So the binding arbitration mechanism, the website, the framework will have a list of 10 arbitrators, at least 10 it says, and there's a method for how they're chosen and how they're put onto the website. And if you get to this point, you and the other party will choose one of these arbitrators effectively to deal with this, and this is an obligation that you have to commit to. So the framework has set up a fund effectively to pay for all of this, and there is a contribution that you need to make to ensure that you are part of this. The independent recourse mechanism is slightly different. So effectively you can choose which mechanism you're going to have for independent recourse subject to some limitations. So if you have non-HR data involved in this, then you do have some choice, and there are some private bodies, some of which are listed on the framework website, who are said to be compliant with the framework, and you can choose one of these bodies, and you will need to sign up to the body's mechanism, confirm that you're active within it, have paid any fees before you self-certify, because again, part of the verification of your self-certification will be that they will check that this has been done. If you have HR data, then you have less choice about this. For HR data, the body involved will be a data protection authority, either the EU Data Protection Authority or the UK ICO or the Swiss authority. So less choice when that is involved. So also, as we've mentioned before, you'll have to have an independent verification process for your compliance plan. You'll need to pick an independent body that's going to certify your compliance. That may or may not be a quick process. If you haven't involved them in your compliance plan, they may have questions and queries and actions that they think you should have done or done differently. So you can imagine that that may not be a quick process to undertake. You also, as part of this process, have to designate the person responsible within the business for compliance. This person will be named on the framework website. They will be contacted. This is an interactive process with the framework, but also with regulators in Europe, UK and Switzerland. So they will have to deal with queries effectively. There will be consequences if the framework deems that a business is not proactively dealing with queries, which can include removing your certification. You'll then have to submit your self-certification application on time with the required additional information. So information about all the things I've mentioned, and not just a tick box. It might be that you have to produce information about it, contact details. You know, outside bodies will be contacted to verify what you're saying. You will also, within your application, have to give out details of your organisation, the corporate setup, details of subsids or other organisations, and they will have to be that will have to be very transparent that it's part of your application in your external documentation that you're updating as well. You will also have to include details of the activities involved with the personal data that we're talking about, so that you know where it's coming from, what you're doing with it, how you're protecting it. So part of your compliance plan will mean that you really need to know this information. Do you know this information already? And finally, you will have to pay a fee. The fees range from $250 to $4,875. The good news is that your fee for the EU framework includes the fee for the UK framework. So it's no extra charge, it's a bargain. If you're paying for all frameworks, then the second framework effectively is deemed to be half price. And the fees depend on turnover effectively. You've also got the fees for the binding arbitration mechanism, any fee for your independent verification process as well. And I think that's it. That's me done.
Thank you. I'll take a couple of questions if you don't mind. So there's one for Camille, which I'll come back to. But first of all, for you, until we have official migration of active US companies and currently on the Shield to the DPF, what should we do? Shall we continue using SCCs?
So
I think you've answered that earlier.
If you're in the privacy, if you go onto the framework website, there is a list. The list is populated by businesses already. So if you're in the privacy shield and you want to continue with the framework, you effectively have immediate protection from it. You can immediately consider yourself as part of the framework. You do need, by the 11th of October or by your renewal date, to have made this public declaration in all your documentation that that's what you're doing. Actually, the website says you should do that as soon as possible, and that is an end date effectively. You will need to certify, but you can consider yourself immediately as part of the framework, and there are businesses named there already.
Thank you. Let me take the next one. What's our advice for in-house counsel in the EU in terms of existing contracts of suppliers which currently refer to SCCs? I guess because they incorporate SCCs by reference. Well, the data is protected, and I'm going to come on to how the executive order will help you do your risk assessment in relation to that. Camille, I want to come back to a point that touches on something that you raised and someone has asked about. How do they know whether they are subject to DOC, FTC, or Department of Transport jurisdiction? You're on mute, Camille.
Sorry, so I'd defer to US counsel, but from my knowledge, the Department of Transportation has got jurisdiction over US and foreign air carriers. And then the FTC, as far as I understand it, their scope covers persons, partnerships, or corporations, save for some industries that fall outside their jurisdiction. And I gave some examples of those: the depository institutions, telecoms. There's also labor associations, non-profit organizations, and there are some others besides. But the Privacy Shield website did have a contact point for parties to reach out to check whether their US-based organizations would be subject to the FTC or the Department of Transportation. So I imagine that the new framework website also has that as well.
Thank you, Camille. So I'll pause on questions and Sarah will moderate any more that come in whilst I'm speaking, which I'm now going to talk about a wider piece, which is what does all this mean for transfers to people, to entities that are not certified to the framework? And the reason the question comes up is because in order for the adequacy decision to have been made, changes were made to US law by the executive order, which I referred to earlier. And you might have a recipient that is not in the framework through choice. You might have a recipient that can't be on the framework for reasons as Camille was just talking about, that they're not subject to the jurisdiction of the FTC or the Department of Transfer. Do these changes to US law actually help in terms of allowing you to transfer with compliance, with no risk? So I've got two slides on this. One is the Commission's view. Let me read it out because it's important. What is the impact of a decision on other tools for transfers, the SCCs? All safeguards that have been put in place by the US government in the areas of national security, including the redress mechanism, apply to all data transfers under GDPR to companies in the US, regardless of the transfer mechanism used. These safeguards include standard contractual clauses and BCRs. So you still need to do, in accordance with the Schrems jurisprudence, in accordance with the EDPB recommendations flowing from that, a transfer impact assessment, but you ought to be able more easily to conclude that the data is protected to essentially equivalent standards in the US because of the executive order's changes. Some of the DPAs have already come out confirming that they agree with that view. The first one out of the blocks, I think, let me try to pronounce him, a Norwegian DPA, but Tilsinet. Any Norwegians on the call, forgive me. The EU Commission has considered US legislation in practices. In simple terms, the Commission believes that these are not a problem. US legislation is not a problem, and that additional measures are not necessary. You can do a transfer risk assessment as Schrems requires, but you may no longer need supplementary measures. There's a little caveat there that you might be subject to different laws, which are out of the ordinary, no mention of what they might be. And then they nicely conclude the demand and assessments have been simplified. They haven't removed the need for a TIA, but they have been simplified. But you always do need a transfer basis, i.e. the SCCs. The CNIL, the French regulator, in its FAQs on the question, the safeguards put in place by the US government in the areas of national security apply to all transfers of data made by public or private entities. They haven't got as far as Norway in saying that you can more easily reach a conclusion that the transfer goes ahead, but that's certainly, in my reading, underpinning that answer to that frequently asked question. I now want to move on to a slightly difficult concept, so I want to apologise immediately before delving into a little bit of detail, which is the question of onward transfers. And just to begin to set the scene here, GDPR, other national laws recognise data is protected within their borders and recognise mechanisms for the data to continue to be protected when they go outside the borders, either through SCCs or in this case through an adequacy decision to the DPF. What mustn't then happen is that the data is then transferred out from that protection. And that's why Camille earlier mentioned one of the important principles in the framework, which was in Privacy Shield and was in Safe Harbor, which is onward transfers. The data must be protected if it's transferred on. Now, if you delve into the detail of that principle, it asks you to put in place certain contractual terms, and I'll come to the detail of that in a moment. But the other question which arises is that in relation to that onward transfer, whilst I might not need to do a transfer impact assessment anymore because of the adequacy decision to the original recipient, do I need to do a transfer impact assessment in relation to the onward transferee? Does the original recipient in the US of that data need to do it, or does the exporter need to do it? So they're the two issues, and they overlap, but taking them one by one. Principle 3 of the framework requires certain terms to be flowed down to onward transferees. A typical onward transferee is when, and let me paint a more detailed scenario. You've got an enterprise cloud service provider in the US with European customers. The typical flow there is that the customer is a controller, the cloud provider is a processor. In turn, that cloud provider will have a bunch of sub-processors, AWS, Microsoft Azure, and so on, perhaps hundreds of sub-processors. They already have in place with each of those sub-processors vendor contracts. Those vendor contracts will reflect the requirements which were in the mechanism that they had in place when they received the data from the EU. In the last 3 years, everyone's been relying on standard contractual clauses. So the onward transfer is likely to be protected by something like the SCCs. And those of you that know the SCCs in detail will know that if you transfer data on as an importer under the SCCs, you either have to make sure that you've got adequacy down the road, or you have to put in place SCCs or similar mechanism. So you've got a whole flurry of contracts already in place with onward transferees. And lo and behold, Principle 3 comes along with requirements as to what you must put into your contract with an onward transferee. And the question that begun to arise of our clients is, to what extent do the SCCs deal with all the principles that are in the framework? And here we have a difference between whether it's a C2C transfer or a C2P or P2 subprocessor transfer. So the typical scenario is it comes over C2P from Europe and it's P2P. Now, so let me take that one first, because that's the good news. Now, a lot of the principles that Camille talked about are in the framework are really, although they apply to all recipients, are really controller type principles: notice, choice, access. These are, in EU law, controller competencies. Now, whilst there is an obligation to flow down those obligations to a chain, you wouldn't really, and no regulator, I think, would expect a processor to flow down a choice and notice principle to a sub-processor. So the SCCs, although don't necessarily map onto all the principles directly, and they don't, I think in relation to the processor scenario, it's going to be good enough. Now, when it comes to a controller to controller transfer, however, unfortunately, there are some principles in the framework which simply don't have a mirror in the SCCs. And one's on the slide, and there's a second one as well, which I'll mention. Principle 3, which is, Principle 2, which is the choice principle. Camille mentioned earlier that onward transfers are only permitted by the person that's certified to the framework if the data subject has been given a choice to object, to opt out. That's not in the SCC. So the data has not been received with that contractual promise to be flowed down to an onward transferee. And there's going to be a gap if you rely on SCCs. Now, it's true that C2C onward transfers are relatively rare in a vendor scenario. It's normally C2P, P2P, rather than C2C, C2C. But nonetheless, if you've got C2C onward transfers, you have a gap. And therefore, you might simply have to take a risk or do a little bit of repapering exercise with your onward transferees. Moving on to transfer impact assessments. So there's nothing in the framework which says that when you transfer the data on, you need to undertake a Schrems assessment in relation to the risk. This was brought up by the EDPB in their reply to the Commission's consultation on the adequacy decision, but as far as we can see, nothing changed. So there seems to be a potential of a gap. So let me just paint 3 different scenarios here. The onward transferee could be in the US. If they are in the framework themselves, then there'll be adequacy. All you need to do is put a normal commercial contract in place dealing with data protection. You don't need to do a transfer tool because the transfer is also adequate. If they're in the US but not in the framework, then you've got a potential issue. You're transferring the data on. Who should be doing a TIA? There's nothing in the framework which requires the original recipient to do so. But the European regulators did say in their recommendations, the EDPB's recommendations, that the exporter ought to be undertaking risk assessments of everyone in the chain. Now, as a matter of practice, a lot of our clients simply stopped at the first leg. It is just too difficult. You imagine, again, a European cloud customer using a US cloud provider. You do a transfer impact assessment in relation to that provider, and they've got hundreds, and literally potentially someone will have hundreds of sub-processors. It is just completely impractical to do a transfer risk assessment in relation to all of them. But the regulators have, and most people haven't that we know of, but the regulators have said that you ought to do that. So might they expect a little bit more control in the contracts with the original recipient of the data in terms of visibility on transferees? Of course, Article 28 requires that anyway if it's a controller to processor type of transfer. So watch this space as to what the regulators might say in relation to TIAs further down the chain. Now, if a transferee out of the original certified recipient in the DPF is outside the US in a non-adequate country, so again, imagine a US cloud provider with a call center in India or in Singapore, non-adequate countries, again, we have a potential gap. If you were to transfer the data directly from the EU to India or Singapore, the regulators would expect you to do a transfer impact assessment, and they're not going to be saved by executive order in the US. It remains to be seen whether regulators will take the view that you avoid doing a Singaporean or Indian transfer risk assessment, in my example, because the data hopped through a recipient in the DPF. I think they won't. That was complex, forgive me. One slide. I hand it back to Sarah.
Yes, and just before I deal with this slide, there is a question that says, can the independent verification of compliance be dealt with in-house? The answer seems to be yes, that is the case. There is some information provided about what this verification needs to entail. If this is going to be done in-house, then a corporate officer or other authorized representative has to sign a statement every year to say that this has been done, and it talks about having objective reviews of this. So the question remains, what would be an objective review? And there is some indication about what this entails. So effectively, a rigorous assessment about whether the privacy policy accurately reflects everything that is happening and is in place. But interestingly, in the section that talks about independent reviews, there's more information about, what needs to be done in terms of verification, and it talks about what audits and random reviews there should be, the use of decoys or other technology. So there's a bit more detail there, but not clear why that relates to an external review as opposed to an internal review. So yes, I think it is possible, and we'll have to consider what needs to be done to make that a compliant, objective, ongoing review that needs to be signed annually by a corporate officer or authorised representative effectively. So just quickly dealing with other consequences and then a quick summary of what needs to be done. So in terms of sort of Q&As, people might ask whether other countries will be joining the framework. And the Department of Commerce, US Department of Commerce, has said no. Its intention is it has a global cross-border privacy rule, which is intended to be multi-jurisdictional. Some other jurisdictions have signed up to this already, and they are promoting this as their sort of global solution rather than adding more jurisdictions to the framework. That's the intention. This I heard this from the mouth of a director at the framework very recently, but I suppose we'll wait and see, but that's the intention at the moment. Also, is this likely to be challenged and invalidated? Renzo referred to this. I think we know there's going to be a challenge. I think the only
I lost Sarah's audio.
Sort of fuel for a challenge is that this would be through the courts, so it would be the CJEU, as in the Schrems II compliance, but the parties involved say this has met those criticisms in the Schrems II decision. It's a more robust framework, and the Biden executive order has made significant changes to laws and practice, as Renzo indicated. Question I've been asked, what does this mean for US states without privacy laws? Does this magically change things in a state where there are no privacy laws? Well, I think the answer is for businesses that certify to the framework, it means consistent DP standards, similar to other businesses in other states certifying to the framework. It's not quite a federal law, but certainly consistency across the whole framework of businesses that certify to it effectively. And that's it, Renzo. I'll deal with a summary, I think, and the mop-up of what we're recommending businesses do. So, as we've been saying, really, assuming you have worked out what kind of organisation you are, what that entails for your certification and your dates, but by all means contact us if you want to discuss that. You're going to need a compliance plan that's going to look at where you are compliant with the principles and maybe what else needs to be done. That's going to involve updating policies and notices as a minimum, but other documentation is probably going to be needed too. Clearly, where we're talking about rights and complaints, this is going to be relevant, so you can see that it's going to be wider than just policies and notices here. You're going to need to select your independent recourse mechanism and become active within that mechanism, pay the fee, do whatever is required to be accepted. So that may take time. You need to get onto that. Need to be ready to make the contribution within your application towards the binding arbitration mechanism. I don't think it is a significant fee. The sums I've seen are fairly small, but bear in mind that there are other fees outside the fees that are mentioned on the framework website. Put in place your independent verification process, whether that's internal or external. That is not just a tick box. Literally, you will have to sign, or corporate office or authorized representative will have to sign if it's internal. If it's external, either the reviewer or those persons within the business will have to sign every year. It has to be objective, and there are indications of what that should involve. So that is not going to be a quick process, and you may have needed to improve your compliance plan before that can happen. You've got to designate the person responsible within the business for compliance, and they need to know all of this information and the detail about your compliance because they will be contacted, and they need to be, proactively responding to queries about this. You'll have to submit your self-certification application on time with the required information, which I've indicated can be significant. You may be having to upload, updated documents and policies, and you'll be asked about it. They will check up on information within your application, not just within your business, but externally. And as Renzo explained, and it is complex, you need to assess your non-DPF transfers and safeguards to check whether they're appropriate and whether you're covered belt and braces.
Is that it, Sarah? Thank you very much.
Yes.
We've only got 2 minutes left. I might whiz through one or two quick questions. UK transfer all, what should we do in the meantime whilst waiting for the UK to find adequacy? Carry on with the SCC, the UK addendum? I guess the answer is yes, strictly. It's hard to imagine, and carry on doing risk assessments, although it's hard to imagine that the ICO is going to heavily enforce transfers.
I'm not sure if it's
given that they never have when you've got this development coming in the pipeline. maybe actually we're on the hour just about, so let me close there. So thank you everyone for joining. As I said earlier, we will send you slides and we'll send you a link to the recording very soon. We do try and deliver a webinar every month. We are going to take a break now for the summer. Don't normally do one this late in July either, so definitely none in August. In September, Sarah will be back, not with me, but leading a webinar on privacy for health and life sciences businesses. If you're in that sector, watch out and get on our mailing list if you are not already on it. In October, Kirsten Whitfield, our recently promoted partner, will lead a webinar on privacy and investigations. So thank you very much, everyone.